This is an appeal in the matter of Groom and the Maritime Coastguard Agency.
Yes, Mr. Tolly.
I'm grateful, my Lord. May I introduce, I appear with Mr. Allsop and Mr. Blitz, my learned friends, Mr. Brittenden, King's Counsel, and Patricia Bogg. I appear for Mr. Groom. May I say first of all, my Lord, that I'm grateful to the court for arranging a 1.5 day listing when the original proposal was 1 day. In the circumstances, my learned friend and I have proposed a timetable, which, subject of course to the court, we've discussed and agreed. What I propose essentially is that we split the time 50-50. That would mean that I would continue till about 2:30 today. My learned friend would then have the rest of the afternoon continue till about 12:30 tomorrow, leaving half an hour for reply.
Well, if it comes to that, then yes, we thought it might be possible to finish today, but let's see how we go.
Very good, my Lord, of course. Can I ask what the best form of references is from my Lords?
Well, we are a split court in the sense that I'm using hard copy,
as am I.
bundles. But Lord Justice Stuart-Smith is
electronic
dissenting in this respect.
Well, I hope that's not a precursor of things to come. But
somebody told me there was a glitch about the pagination. So, see how we go. I
Very
think
good.
the core and supplementary bundles, there's only one set of page numbers. The authorities maybe not, but it's usually possible to work out what case we're looking at.
very good, my Lord. Tabs will presumably be helpful then, as well as page
Tabs
numbers.
will be helpful, and there are numbered tabs in the authorities bundle.
Very good. And can I check that the court has obviously got the core supplementary and authorities bundles? Can I check the court has had both the original skeletons and the supplementary skeletons that each of the parties filed?
Yes.
Okay. So can I just update the court before I get into any substantive submissions on the question of the new point dispute, if I can summarise it like that? Your Lordships will have seen from the supplementary skeletons, well, certainly from a learned friend's original skeleton, that he objected to certain of my submissions on the basis that they were new points for which I needed permission. I put in a supplementary skeleton to explain why they weren't new points, or if they were, why I should have permission. At any rate, that dispute has narrowed significantly between the parties. Obviously, it's a matter for my Lord ultimately. But my learned friend has indicated that he doesn't seek to take that objection in respect of my submissions on grounds 1 and 2, but does seek to maintain that objection in relation to the point on ground 3, which I can call for short the window point. But he says that's a new point, which I shouldn't be given permission to run. What I propose, of course, again, always as ever subject to my Lord's direction, is to make my substantive submissions and on the premise, as it were, that there's still a live procedural dispute about ground 3, to deal with my learned friend's objections in reply, and therefore to address my Lord to address the court on ground 3.
I can't remember, speaking to myself, what the window point is, but rather than deal with any of this as a preliminary point, when you get to it, you can note that Mr. Brittenden says you shouldn't be raising this point, and we'll deal with it in the course of the case.
I'm grateful, my Lord. And I just wanted to say, lastly, by way of, as it were, case management things, that the position about sharing submissions has at least been considered, but in the circumstances of this case, I'm afraid my Lords will only hear from me. And I obviously, as a matter of good form, I continue to rely on the contents of the 2 skeleton arguments, but what I'll aim for, I hope, is elucidation rather than mere repetition.
Right.
So I'd like to start, my Lords, with 7 short topics by way of overview before we get into the detail of the grounds. As my Lords will be aware, this is an appeal about the worker status of Coastguard Rescue Officers, which I'll call CROs for short. And I'll refer to the appellant, the Maritime Coastguard Agency, as the MCA. Mr. Groom is obviously Mr. Groom. So the first topic by way of overview is the general importance of this appeal. Obviously, it's something that my Lord recognised in granting permission to appeal. Can I just briefly say three further things about that, just to, as it were, illuminate the position? The current population of CROs is about 3,000. I can tell the court on instructions from the MCA that the MCA considers that its CROs are entirely or mostly entirely motivated by a strong sense of commitment to public service, and that many CROs are not agitating to be treated as workers. It's obviously an issue of law, and it's not a matter of vote. And I would like to acknowledge on behalf of the MCA, because I appreciate there are probably a lot of people following these proceedings, that a dispute about the status of CROs in the Court of Appeal is bound to be unsettling for those CROs. And there's a concern about the effect, actual or perceived, on the standing of CROs generally. In other words, some wish to be regarded as workers, some do not wish to be regarded as workers, and to that extent, the appeal has wider ramifications. The other point, and more generally, my lord, if I may, is that there is a potential, if not a strong analogy, between the position of the MCA and its CROs and other search and rescue organisations in the UK, including but not limited to the RNLI, Mountain Rescue, and many others. And I'm told on instructions, my lords, that there are potentially as many as 30,000 individuals in a similar situation in the search and rescue field. So that brings me on to more substantive legal points. The first, perhaps obvious, but if I can just emphasise it from the outset, the issue that my lords are concerned with is one of statutory construction. And the issue is that the worker's statutory right to be accompanied under Section 10 of the Employment Relations Act. And I'm sure my lords have got the point that the definition of a worker for this purpose is the definition in the Employment Rights Act, Section 230. Can I invite my lords to turn that up? I know my lords have, as it were, seen it in the course of preparation. It's in the authorities bundle, tab 1, page 4.
Yes.
And we'll see the definition of worker in subsection 3. And in this case, it's only limb B that's an issue.
And shall we, let's agree that when we talk about workers, we mean limb B workers, so we don't have to trot out this tiresome phrase.
Quite so, my lord. But can I just flag that the reason that limb A is not an issue is an accident of procedure in this case, in the sense that Mr. Groom asserted a claim of unfair dismissal but did it out of time, and it was ruled out on jurisdictional grounds. So the Employment Tribunal considered at a different hearing, my lords have got it in the supplementary bundle, tab 4, page 31 for reference, a different employment judge's decision on the time point, ruling out claims that would have turned on Mr. Groom having a contract of employment. But while my lord is right to shorten it to worker for the purposes of this debate today, I just wanted to indicate that the lack of a claim under limb A is inadvertent rather than deliberate in the context of this case.
It's not your case, is it, that he did have a contract of employment?
Not at all, my lord. I just wanted to make clear that there could yet be a debate about that, depending on the way my lords resolve this appeal. That's all I wanted to indicate. So there are 2 points, if I may, in terms of what matters to my appeal. First of all, that a worker has to have a contract because of the first 3 words, any other contract. But obviously it can be express or implied, and if express, oral or in writing. And then there's a further requirement as to the type of contract. It must be one where the individual undertakes to do or perform personally any work or services for another party to the contract. I can clear the decks, I hope, of the word personally in this case. There's no issue that if there were an obligation, it would be an obligation to do the work personally. There's no question of a substitution arrangement or anything like that. And lastly, the proviso to the definition of worker whose status is not, etc. There's no issue about that either. So what we're focusing on are the words any other contract whereby the individual undertakes to do or perform personally any work or services. Now, my lords may be assisted, certainly there's an authoritative assistance to be derived from a passage in a recent decision of this court in Somerville. My lords have in the authorities bundle at tab 30, that's page 504, for the head note. I'll come back to the case.
On your 7 short topics, where have you got to?
Number 2. Number 1 was the general importance. Number 2 is statutory construction.
We're dealing with statutory construction.
Just to give my lords the basics, if you like,
Yep.
right at the beginning. And I'm showing my lords Somerville. We'll come back to the detail of it so far as necessary in due course. I want my lords to see on page 515, under page 515, paragraph 45. Can I check whether the printed version has continuous page numbers or whether my lords need report page numbers?
The printed version has continuous page numbers, and it's encouraging that paragraph 45 of the judgment is on page 515.
Very good. Well, that's a good start. So, my lord will see that here, Lord Justice Lewis, as it is, sets out in, as it were, stages what the number of elements are in the definition. Can I check whether it's more convenient to my lord simply to refer my lords to paragraphs, or whether the preference would be to read out relevant passages?
Well, don't read it out. We'll read through 45.
Please, I'm grateful.
Yes.
And so just to locate the present appeal within that analysis, I say the issues here are partly of the first type that Lord Justice Lewis identifies. Is there a contract? In other words, are there legally enforceable obligations owed by the parties? And there's also an issue of the second type, the way his lordship puts it as next against G. The contract must include a certain type of obligation. And the question is whether the individual undertakes to do or perform any work or services. As I say, there's no issue about to do so personally.
Is it do work or perform services?
So my lord will see the...
And does the word personally govern both?
So the statutory phrase, my lord, is undertakes to do or perform personally any work or services.
It's do work or perform services, both of them personally.
The word personally governs both, quite so, my lord. And the do or perform is perhaps correlative with work or services. But one could see how one could perform work, but it would be awkward to talk about doing services. And just to pick up another bit of linguistics, which is, I hope not difficult, but to make sure my lords have the point, where the definition of worker refers to undertakes, Lord Justice Lewis explains in Somerville that just means promises. And the reference for that is paragraph 55, which my lords will see at page 521. Just against G, there's a sentence that begins undertakes to do or perform, and my lords will see that simply means promises to do or perform.
Please, any word which involves accepting that there is an obligation of some kind to do it.
Quite similar. And just for my lord's note, I won't take my lords to this now, but there's a relatively recent decision of His Honour Judge Taylor in the Employment Appeals Tribunal, where he sets it out a little differently, and it might be of assistance or it might not. But then, for my lord's note, it's Authorities Bundle, tab 31.
But none of this is new, is it? It's endlessly paraphrasing. Things were said in Uber, things have been said for decades. I'm not saying that Lord Justice Lewis or, for that matter, Judge Taylor could change the law.
Not at all, my lord. It's only because other judges have attempted to offer a paraphrase that
Yeah.
may or may not have been some assistance to my lord. If it's not, it's not. But I'm moving on now, my lords, to the third overview point. It's just some observations about language, and it's addressed at greater length in my supplementary skeleton. But let me just explain, if I may, two things. The first is this: in terms of my approach, I'm going to try my best to avoid begging the question by putting things in a coloured way, to talk about volunteers rather than people who have obligations and that kind of thing, to try and focus on the legal issues my lords have to decide, rather than nudging it one way or the other with words. Can I just also clarify that where I refer to legal obligations, I'll say so, because there's obviously a looser sense in which the word obligations can be used. I would try and avoid blurring the line. And if I mean contractual obligations, I'll also say contractual rather than legal, because obviously there are more than one kind of legal obligation.
Does the undertaking itself have to be contractual, or can one have a non-contractual undertaking which arises under a legally binding contract, or there is a legally binding contract whereby, to use the statutory word, a non-contractual undertaking suffice?
So my submission to my lord is that it would have to be a contractual promise, because it's a contract whereby the individual undertakes. So it's a contractual promise to undertake the work.
And if you had a contract which contained contractual enforceable terms, but within that contract there was a provision which was a promise but not intended to be a legally binding promise, that couldn't qualify.
Quite similar. There are two distinct points: that there can be a contract so that it satisfies that part of the test,
Yes.
but if it doesn't contain the legally binding promise to do something, I say then it doesn't qualify as the right kind of contract.
But why is that? If the wording of the statute is stage 1 there must be a contract, stage 2 there must be something under that contract, stage 3 there must be an undertaking. Why must the undertaking be contractual? It often may be, but why does it have to be?
Well, I'll make two observations, if I may, my lord. One a matter of interpretation, and one a wider response to my lord's point. The answer by way of interpretation is a contract whereby the individual undertakes is a reference to, as it were, is another way of saying pursuant to the contract. In other words, the undertaking is pursuant to the contract. I know that I'm paraphrasing now, my lord, but I'm offering a submission about what whereby the individual undertakes means in the definition on page 4. That's certainly how it's been understood in the cases, and I'll show my lords the authorities in due course. But the wider point as to why should it be so is that what as has been explained in a number of cases, particularly, we haven't got this one in the bundle as it so happens, but what the definition of worker with which we are concerned was seeking to do was to distinguish between a type of person who would at common law be self-employed, but who merited statutory protection, and a type of person who is self-employed and doesn't merit the statutory protection. And so the Lady Hale had emphasised that there are, if you like, three types of case, albeit she was concerned in Bates and Van Winklehoff with a member of an LLP, three types of case covered by the definition, as it were, classic common law employees. Secondly, people who are not common law employees but are nonetheless worthy of employment rights of a limited and more limited kind, and then those who are beyond the scope of those employment rights, statutory employment rights. So it's an attempt to delineate, my lord, who should be entitled to these kinds of statutory rights based on the meaning of worker and who's beyond the scope of them. The other point I wanted to observe about language is just the relationship between the statutory word worker and indeed the statutory word work But if I can just observe this, my lords, that on the premise that a person is a worker within the meaning of the statute, what they do, their output, will necessarily amount to work for the purposes of the statute also, whereby the individual undertakes to do or perform personally any work. But the converse, I submit, isn't true. Not all work is done by a worker. So to give my lord some natural uses of language, it would be perfectly natural to speak of work being done, even though there's no legal obligation to do it. An example in ordinary speech would be household work or caring work. It's work for sure, but it's not the sort of work that involves an obligation, a legal obligation to do it. You can do it if it's a person's job, but what I mean to say is that kind of usage of language isn't any kind of misuse. It's still work, even though it's not work pursuant to a legal obligation. And then this further observation about the concept of work, if I may, that work can be paid or unpaid, and it can be voluntary or obligatory. And I appreciate my lords are trying to resolve what the nature of this particular arrangement is. But I say, just in response to my Lord Justice Popplewell's point earlier, if I can add this, that the definition of a worker requires that the work be done contractually, that it's obligatory. It also follows, if I may, that if work is obligatory, then a person will necessarily, as a matter of statute, be entitled to pay for it under the National Minimum Wage Act, if nothing else.
Well, what do you mean obligatory?
In other words, if a person is a worker, as a matter of this definition, it's the same definition in the National Minimum Wage Act. And so a person who is a worker and satisfies this definition will qualify for the right to national minimum wage under the 1998 Act. And so will necessarily have a statutory right to be paid. That's all I wanted to observe, my lord, that satisfying the definition of a worker brings with it a statutory right to payment, whatever may be the contractual or non-contractual arrangement. But obviously on the premise that the work is contractual is what I'm saying, the person will be a worker and will necessarily be entitled to payment. The converse is the submission I will offer, but I'll come back to this and seek to make it good. Where work is paid, it doesn't follow, in my submission, that either the work or the payment is obligatory. Work can be paid, in my submission, without a contractual obligation, either to do the work or to pay for it.
And when you say obligatory here, you said you're going to be careful. You're not. What's the source of the obligation that you're talking
A
about?
contractual obligation, my lord. I apologise for not being careful. I apologise for not being good as my word.
It doesn't follow that either the work or the payment is contractually obligatory.
Quite so, my lord. I'm grateful.
Can you just say that again? I was going to write it down and then you moved on.
Yes, of course, my lord. So the point with my Lord Justice Stuart-Smith's helpful correction is this, that I submit that if work is paid, it doesn't follow in my submission that either the work is done pursuant to a contractual obligation or the payment for it is made pursuant to a contractual obligation. It may be, and it may be an indication that it's so, but my essential submission is it isn't necessarily so, and one needs to be careful. And I emphasise the contractual obligation as my Lord Justice Stuart-Smith rightly pointed out. So that brings me to the fourth overview point. I hope I can be quite quick about this one, about the correct approach to this appeal. The relevant question for my lords is, of course, whether the Employment Tribunal's decision was legally sound and not whether the EAT's decision was. And my Lord Justice Bean made that point in Robinson and DW.
Well, of course, this is very familiar, but it would be pretty unsatisfactory in this case to say, well, Judge Canley was entitled to form his view on the facts. Who knows? The next employment judge with the next case where somebody raises this may come to a different conclusion, and that's not why we're here, is it?
Well, if I may, my lord, I agree.
Yes.
But it's not for me to dictate to this court how it resolves a case before it.
Yes.
Certainly, I welcome the court's willingness, one way or another, to grapple with a substantive question. But I do make the point that ultimately the focus of my submissions needs to be on whether the Employment Tribunal's judgment was right.
Yes, that's right, strictly speaking. But in a case with agreed facts, and it's not suggested there's anything terribly special about Mr. Groom's agreement with the MCA, I imagine the parties are asking us to give a ruling as to which decision was right in law.
Thank you, my lord. I'm certainly grateful for that indication. The second observation, if I may, about the correct approach to the appeal is just to refer to my Lord Justice Popplewell's comments in Greenberg and DPP about the benevolent reading of decisions, and if a tribunal has correctly stated the legal principles, one can normally assume that it's applied them. Again, I'm not going to take my lords to those passages. They're very well known. They've become an EAT familiar authority. Moving on to the fifth overview point, there is a specific observation to be made about the approach to appeal about worker status, noting what my Lord Justice Bean has just said. But if I can just flag it to show you the passage, it's part of Uber, which is at tab 27 of your authority bundle. The passage is at page 465. Can I invite my lords to review paragraph 118 on bundle pack 465? 118. I'm good.
Yes.
I'm going to come back. I just wanted to draw my Lord's attention to it. I'm going to come back when I deal with ground one to the question whether the present case was, if you like, properly regarded as a Davies and Presbyterian Church type case, where all the relevant information is in a document, and the only issue is the construction of the meaning of that document, or whether it's a Carmichael type case, that there were important elements of factual evaluation involved. I take my Lord Justice Bean's observation that what matters is the substance, but there is a point of substance as to the nature of the exercise in a case like this. And as I say, I don't want to jump the gun. I just simply wanted to flag that where there is a factual evaluation, I say this is a case that does involve a factual evaluation. One needs to be, as it were, cautious before interfering with an employment judge's decision. And then there's a substantive underlying point, which is what is the nature of the analytical exercise in a case like this, in deciding whether there's a contract or not. And as I say, I'll revisit that in more substantive terms in due course. So the sixth and penultimate overview point is just to say a few words about the recent Supreme Court decision in PG Mall. I know my learned friends have called it match officials. I'll call it whatever my lords prefer, referees, whatever's convenient.
Same case, yes. I think either call it the match officials.
Very good. So it's clear now, and I hope this doesn't require a lot of citation. It wasn't already clear that under the test for employment or worker, there's no need for there to be a prior obligation to work before the work is done, provided that the work itself is done pursuant to an obligation. In other words, there doesn't need to be an antecedent obligation. The fact that the referee took on the obligation to referee the match, that could cancel before he turned up to do it, wasn't fatal to the proposition that when he did the refereeing, he was doing it pursuant to an obligation. And similarly, the fact that there's an obligation on a particular occasion of work.
Sorry, Mr. Tommy.
Did that obligation arise with the referee who could have cancelled but didn't? Does the obligation arise, the obligation you're talking about arise at the moment he walks onto the field or previously?
The obligation is undertaken when he accepts the assignment to do the refereeing. But he is free on the terms of the particular arrangement in PG law. The referee is free to back out before the match.
So if he then goes on and does not back out, it's within the terms of the statute.
Quite so, my lord. It's been, the decision on the facts has been remitted to the first-tier tribunal to be reconsidered. But on the question of principle, once the referee starts to referee, he's doing so pursuant to a contractual obligation to carry out refereeing work. The fact that he can back out before the match starts, or indeed before he turns up at the ground, doesn't change the legal character of what he is doing when he does it.
Really? Can he say at 10 to 3, I've changed my mind, I'm going home?
Well, 10 to 3 may be pushing it, my lord, because he should have turned up at the ground by then. Once he's turned up at the ground, that's the, as it were, that's the seal on the application, on the obligation, the contractual obligation, if I can put it like that. But he's free to back out the day before. Obviously, in the context of the sort of professional refereeing we're talking about, one suspects that if one made a habit of that without good cause,
Forget work again.
quite so.
But is the analysis, which, as I understood it, is there is once he agrees to referee, that's when the contract comes into play. He may be in a position to cancel it at his option, but if he doesn't, then once he starts working, he's working pursuant to that contract, which has always existed since the moment he agreed to referee.
Exactly so, my lord.
That's the analysis.
It's exactly so the analysis, my lord.
Assuming there's a contract.
Yeah, on the premise that there's a contract, but that's the effect of the outcome at the Supreme Court, that there is a contract for each match. The question is still to be decided: is it a contract of employment or a contract for services? That's been
Equivalent in our case would be when he accepts to do an assignment. That's when the obligation is undertaken, notwithstanding the fact that he could arguably back out before discharging that obligation.
well, yes, my lord, but I would go further on the MCA's case. Even after the individual turns up to a call-out, he's free to leave. There's no obligation to stay. There's no equivalent of the referee having to see through the match.
In your case, that I mean, although obviously it would be deeply unsatisfactory if he bails out halfway through an undertaking or immediately before, but is it your case that if he does that, the sanction is that he ceases to be a volunteer?
Not at all, my lord. Not at all.
Your case.
Not at all.
Or can be his status as a volunteer can be terminated.
Well,
Or is it that he could be sued?
certainly not sued, because my submission, my lord, is there's no contractual obligation at all at any time. Plainly, there are some very hazardous activities that are undertaken by CROs, and there are people who need helping who are in deep hazard. And so there may be circumstances, my lord, where liabilities in tort could arise. If
That's different. Well,
but that's a different matter. What I say though is a matter of contractual analysis. A CRO is never under a contractual obligation to turn up, or having turned up, to stay.
but assuming, sorry,
No, you're gone.
assuming that you accept that there is a non-contractual obligation when the person says yes, I'll turn up on Tuesday. what if any is the sanction if he then breaches that obligation?
There is no sanction.
Well, is that right? Because the code of conduct, or whatever it's called, says you've got to turn up for a reasonable number of things and you've got to behave professionally. Why isn't there a sanction which your clients can say, this is, although it's non-contractual, this is inconsistent with your continued status as a volunteer?
I follow my lord's question. It may be that there's an element of unintentional loading on the question of the word sanction. In other words, there can be a consequence in that sense, a sanction, but it's not a contractual sanction. It's not a contractual response to a contractual default.
By definition, this is on your premise that it's not contractual.
Quite similar.
But I just wanted to be clear whether you call it sanction or consequence. On your case, if he fails to discharge the undertaking, the non-contractual undertaking, what are the consequences?
Well,
Potential consequences.
in my submission, there are no consequences in the sense of it's not a breach of anything. But obviously, if there were a pattern, let me add to my lord's surmise with some additional facts. Let's say there was a pattern of somebody agreeing to turn up and then cancelling at the last minute, which raised questions about their commitment to being a CRO. In circumstances like that, there would be likely to be a discussion about that person's commitment, and if it were considered that their commitment was lacking, then it might be that their membership of the CRS, the Coastguard Rescue Service, would be terminated. I acknowledge that as it were, a logical fact pattern, but to talk about any particular instance, and if I can give my lord's a practical example, which I hope is well within the realms of realism, there can be search and rescue activities conducted by the MCA, and the person hasn't been found. The person who's being looked for hasn't been found yet. But a person who's volunteered to turn up and conduct and assist in the search might not be able to stay to see the whole thing through. In other words, the search has been undergoing for a couple of hours. The poor individual hasn't yet been found. That CRO has to go home or has to get back to his or her regular job. They can't continue and see the search through. And they can leave in those circumstances without any breach of any obligation.
But isn't that because the undertaking agreement, try and find a non-loaded word, was to turn up for a particular period of time?
But it doesn't quite work like that. I mean, the example my Lord Justice Stuart-Smith gave of somebody agreeing to turn up on Tuesday, I mean, these are emergencies on the whole. So that it's not a question of offering a commitment to turn up on Tuesday. It's a question of getting the call on Tuesday afternoon and can you drop what you're doing and turn up?
Can I just try and distinguish between an undertaking and a contractual undertaking?
Yeah.
When a volunteer is called and says, yes, I'll come to an incident, they are undertaking, leave aside whether it's a contractual promise or whatever, they're undertaking to turn up. They may be entitled to renege on that, like the match referee, but if they turn up, then they're engaged in the activity. But are they not then undertaking, not necessarily contractually, but like the match referee, to see the incident through? Are they, in a non-contractual sense, entitled to say, when they've got to the stage where they found the person in the water, and the senior officer says, now throw the rope now, to say, well, do you know what, I don't really feel like it, I'm going to go home now. Are they not undertaking, in at least a non-contractual sense, are they not agreeing that they will turn up and see the rescue through? Subject, of course, to maybe points about it taking too long, not finding the person and so on.
Well, may I make a general point and then answer my Lord's question directly? The general point, of course, is this, that the sort of people who work as CROs are not the sort of people on the whole who will as it were, renege, because they are people who, because of their sense of public service, we want from their own volition and motivation to see it through. But to answer my lord's question directly,
That's a motivation for them agreeing to do it, undertaking to do it.
but the direct answer to my lord's question is they are free as a matter of the arrangements, characterise them how you will, to leave. Plainly, if there's an emergency and somebody's life is in their hands, it's unthinkable that they would do it because of the sort of people that they are. But as a matter of contractual analysis, they would be.
No, it doesn't
Well,
matter whether
non-contractual
contractual.
analysis.
Let's look at, for example, they may think, do you know what? I think this is the wrong moment to throw the line. I don't think that's how it ought to be done. But the code says, I can't remember whether it's the code or the other document. You must follow the instructions. You must follow the instructions of the person having authority. Are they not agreeing that that's what they'll do? Pursuant to good discipline and seamanship. It might not be unthinkable that they'd think, do you know what? This chap doesn't know what he's doing. I don't think that's the right thing to do. Are they not agreeing leave aside whether contractually or not? Is that not something they're agreeing to do when they agree to come to an incident?
I'm going to show my lords, insofar as necessary, the code documents in due course. But the short answer.
No time like the present, Mr.
Well,
Tolley.
very good, my lord.
I was looking at it now.
Let's have a look in the supplementary bundle.
Yeah.
If my lords don't mind, page 11 is the volunteer handbook. Tab 3. And I'll come back to the introduction if I may, because in my submission it's important. But in terms of the points that are being raised in terms of the nature of the commitment and the code, my lord, see the volunteer commitment on page 17. Where it explains what the nature of the commitment is to start with, and then it goes on to set out in bullet points what the HM Coastguard will do in return, what they ask of the individual, the CRO. And then over the page, at page 18, is the code of conduct for CROs. And the way it's put, my submission, consistently with its legal nature, is that this is what the CRO is expected to do. And as a Coastguard Rescue Officer, you're expected to abide by the following code of conduct.
Now they're not quite the same as what we get in the Code of Conduct itself at page 8, but there's a lot of overlap. But in the Code of Conduct at page 8, they're expressed: a Coastguard Rescue Officer must act in line with policies, carry out all reasonable requests, and so on. So I understand that when we're looking at the document at page 18, you're keen to emphasise that it's expressed in terms of expectation. It's also expressed in the Code of Conduct as a matter of obligation. Neither of those may be conclusive or indeed very, very helpful.
Well,
but in terms of what it is that the volunteer is agreeing to do, undertaking in a non-contractual sense, or it may be contractual, leave aside whether it's a promise in a contractual sense, what they're agreeing to do when they agree to respond to an incident is to behave in this way.
yes, my lord. I accept that, my lord, but with the overlay, I mean, even in the wording of the code at page 8, my lord sees in the second paragraph there before the must part,
Yes.
that it sets out guidance as to what's necessary to ensure CRO's safety, the safety of others, whilst carrying out the role, and desirable to maintain the professional image and reputation of the CRS. So that is the overlay for everything that follows.
Yes.
If I can phrase it like this, my lord, to avoid any sense that I'm not answering my Lord's question. That plainly sets out the parameters of what's expected on both sides. And if my Lord wishes to put it in terms, it sets out the parameters of what the parties have expressed to each other as their accord, what they will do for or to each other, then it does that too, my Lord. It may beg the question, and I say it does, as to the legal quality.
I'm leaving that entirely on one side
Quite similar.
for the purposes of my questions, and just looking at what it is that, in accordance with what the person has agreed to do, let's assume for the moment non-contractually,
Yes.
what they have agreed to do, whether that does really involve them undertaking to do some things, agreeing to do particular things which they can't pull out of.
Quite similar. But the issue, as I said earlier, in answer to my Lord's question, was that what they have to agree to do is to agree it in a contractual sense in order to come within the definition.
That's the question we've got to decide.
And I appreciate my Lord.
I'm just looking at the practicalities.
Of course, of course. But plainly, in order that somebody turns up, they have to know that there's an emergency, and they have to respond to the communication that there's an emergency with a willingness to attend. So in that sense, you could say there's an agreement that the individual will turn up because they've been asked to turn up and they have.
Yeah, the point I was trying to do is that there's a willingness, stroke agreement, use what word you will, more than just turn up, but to carry through all these different aspects of what's involved in a rescue.
Yes, my Lord, but where I would balk and say that there is no basis to go this far is to say that the individual is agreeing, even in a non-contractual sense, to see it through. That is not, that's not a requirement or an expectation that's stated anywhere in any of these documents, that having agreed to turn up at an emergency, the individual is expected, required, obliged to see the emergency through to its ultimate conclusion.
Thank you.
So why isn't that covered by number 3 on page 8? Carry out all reasonable requests made by Coastguard Management or CROs in a position of it when responding to call-outs or undertaking training. Just picking up on my Lord's point, doesn't that indicate that where the CRO responds, the expectation, however it's framed as an obligation, the expectation is that when they turn up, they will do what they're asked to do. So there isn't an unaddressed freedom simply to turn up and say, well, actually, it's pouring rain. I don't fancy it. I'm going home.
Well, if I may, my Lord, there's a distinction I'd like to articulate in the point that my Lord's just offered. It's this: there's a distinction between the performance of the work of a CRO, and there's no great dispute in this case that there is obviously a good deal of control of how that performance is manifested. It needs to be controlled in order to achieve the safe outcomes that is the function of the CRS in the first place. On the other hand, my Lord, there's a question of a requirement being imposed to stay against the individual's will. In other words, if I can offer, I appreciate how infrequent this is becoming the case as a matter of practice, but an employee who has agreed to work 9 to 5 isn't free to say for no reason at 2 o'clock, I'm going home. Whereas the difference in my submission in a case like the present is that the search may not have been concluded, but the individual is free to go home, and it wouldn't be covered out in my submission, my Lord, certainly not in terms of the party's understanding, by a reasonable request for the senior officer, the station officer, to say to the individual, you must stay.
Well, some requests may be reasonable, some may not. I've been giving you some examples of what might be regarded as more reasonable requests in the middle of saving life at sea.
Yes.
I take your point that characterising it as an agreement to see it out or see it through doesn't cater for the sort of circumstances you've been explaining. But if it's an agreement to carry out all reasonable requests, then it may prevent a person from not seeing it through, in the sense of that being something they've agreed to do. Leave aside the question of whether it's contractual or not. I think that's really the point that I was putting to you.
It's very good, my lord. What I would say as a matter of ultimate submission is that there would be circumstances in which, as a matter of ordinary language, leaving aside any question of legal analysis, it would be unreasonable for a person to leave partway through. They would be letting down their colleagues and no doubt.
Of course, that's the easy part. But you're laying great emphasis on the fact that CROs never have to turn out if they don't want to, as a matter of obligation. But nor did or do the Uber drivers. They never had to do any work at all. They'd quickly be bankrupted if they never did any work. But there's no obligation to turn out for 5 days a week, 1 day a week, a few hours a day, nothing.
But the difference, if I may, my lord, is this: that the Uber driver isn't free to stop the journey halfway through. So, having started the journey with the passenger in the back, the Uber driver is not contractually entitled to cancel the trip.
No, but
This, to my way of thinking, this has an air of complete unreality about it. So someone's stuck halfway up a cliff. As I understand it, call goes out. Everybody, we've got a problem. Turn up. If Fred turns up and says, "Here I am," the implication there is that he's agreeing to see the job through. If Fred turns up and says, "Here I am, but I'm on night shift at 5 o'clock, I have to be gone by 4:30, then I can see the Coast Guard may say, "Okay, well let's hope," but at 4:30 he goes, no problem. But unless there's some justification, the whole structure of this arrangement is to ensure that people turn up, see out the crisis, and so on. So the fact that they didn't need to turn out in the first place is irrelevant, because in the same way as you accepted that when someone does the work, it's pursuant to the undertaking that they gave earlier. When the person turns up, on my understanding of how it works, there is a clear implication, which is supported by terms of the Code of Conduct and so on, that they've turned up to do the job, and that's the undertaking.
I understand my lord's factual point about the person halfway down the cliff who's being saved, and you can hardly, as it were, let go of the rope. That's obviously, as my lord says, that would be unreal. But a real example is a search that's underway, but hasn't found the victim of the search, the subject of the search yet, and a person can, having agreed to turn up, change their mind. There may be something that supervenes in their ordinary work or in their home lives that requires them, in their own mind, to go home, to go back to work, and there would be no restriction at all on that happening.
I find it easy to accept the submission that there's no contractual obligation. This is all done contractually. I'm not giving an indication, but I can see how that works. But I have to say that I find your submission that halfway down the rope they can just say I'm off, not supported by the documentation or what I understand about the facts. There we are.
But, my lord, can I offer this analogy that once the referee has started refereeing the match, if he walked off the pitch halfway through the first half, he would be in breach of contract.
Or breach of engagement if it wasn't contractual.
Yes, he'd be in breach of what he had agreed to do.
Yes, but
Whether that's contractual or not, we know it is for referees. But the point is, once he's started, what he's agreed to do does involve carrying it through. And all I think we were putting to you is whether you put it in terms of carrying it through in all circumstances, or whether you put it in terms of the documentation of complying with all reasonable requests, which is perhaps deals with your example of been going for 2 hours, I've got to go home now. That what the volunteers are doing when they turn up in this case, like the referee, is agreeing to comply with reasonable requests to see it through. Whether that's contractual or not is an entirely separate question. Just looking at what they are undertaking in the general sense to do by turning up.
Yes, I mean, by the very nature of these sorts of circumstances that we're talking about, there's an element of uncertainty, perhaps a very strong element of uncertainty. It's not known when somebody responds to a call out what they may be getting themselves in for. And it's possible, if I may, my lord, that a person responds to a call out prepared to see it through come what may, and a person responds to a call out on the basis that they've only got a couple of hours free and they'll offer those hours but no more. My point, my lord, is that the individual who thought he was coming out to see it through could change his mind and leave after 2 hours if his circumstances changed. And that's not because there's a contractual right to change his mind, but because he was never under an obligation to stay in the first place. That's the legal obligation to stay in the first place. That's the way I
follow. Thank you. I'm sorry, I've taken up too much of your time.
Not at all, my lord. It's helpful. I was just finishing, if I may, the point about the referee's case. All I wanted to emphasise, my lords, that the key legal focus is on the status of the individual when she or he is working. If you like, is there a present obligation to work? It doesn't matter whether there was a past obligation to turn up, and it doesn't matter whether there's a future legal obligation to come back again. What matters for the purposes of legal analysis is when the work is being done, is there a present legal obligation
that's
to do
common
it?
ground, isn't it?
Yes, quite similar. That's what I wanted to be clear about. That it's only because in my learned friends' submissions, I say that they're mischaracterising the MCA's position. They're saying that my submission to my lords is the same point that was raised and rejected in Somerville and in the referee's case. That what matters is that there should be an antecedent obligation before any particular assignment is accepted.
And you're not saying that.
I'm not saying that, my lord. My case, and we've been through it in the dialogue, but and I'll come back to the detail on the authorities. My case is that there is no contractual obligation on a CRO, even when the work is being done. And putting it in the language of past, present, and future, my submission is there's no present obligation. There's no past or future obligation either, but there's not even a present obligation. So, my lord, that brings me. Sorry, there was a seventh and final overview point which I advertised. It's very short, and that is just to clear the decks in case there was any lingering confusion. 3 points that are not in issue, amongst the others that I've already enumerated. The first, ground 4 in the grounds of appeal is not pursued. Just so my lords have got that point. I'm sure my lords saw that in the supplementary skeleton. But
What ground 4 was?
that was a point on whether the right to be accompanied continues to an appeal. It's not pursued, my lords, to concern themselves with it. The second point that isn't live before my lords is whether the arrangements between the MCA and a CRO involved any kind of umbrella or overarching contract. That point was raised and rejected in the Employment Appeals Tribunal. And for my lord, note it's paragraph 39 of the EAT at page 46 of the core bundle. So the only issue is the characterisation of the arrangements when a CRO responds to a call out and whether there's a contractual obligation to see it through or to remain or to perform in that sense. And the third and last point that isn't an issue is the relevance or otherwise of control. In other words, as I acknowledged to my lords earlier, it's obvious that there needs to be an element of control over how the work is done. That was one of my learned friends' grounds of appeal to Employment Appeal Tribunal, but that was dismissed by the Appeal Tribunal on the basis that it misunderstood or mischaracterised what the Employment Tribunal was saying. In other words, Judge Kedney was saying, yes, there's plenty of control, but it doesn't help you to distinguish between a contractual arrangement and a non-contractual arrangement because of the reasons why that control is imposed. And so that point was taken on appeal by my learned friend. There was an error of law. Deputy Judge Mansfield, Mr. Justice Mansfield, of course, as he now is, rejected that
As he
argument.
will be next week anyway.
Well, very shortly, of course. But my point is that point isn't live. It hasn't been renewed to the Court of Appeal. So my lords don't have to concern themselves with whether the degree or quality of control that's exercised casts any relevant light on the question whether an individual is working pursuant to a contractual obligation or not on the facts of this case. So I'm going to move on now, my lords, with a lot more detail about ground one. The premise of ground one, of course, my lords, is that the EAT was wrong to interfere with the Employment Tribunal's evaluative decision. But I acknowledge what the Lord Justice Bean indicated earlier on, and I'm going to focus my submissions, if I may, on the, as it were, the underlying analysis, rather than simply, if you like, the procedural type point of the filter on appeals to the Court of Appeal. But just from my Lord's note, not taking anybody to it. This is our original skeleton argument in paragraphs 24 to 37, and our supplementary skeleton 12 to 15. So the first point, if I may, my lords, is the nature of the exercise, the analytical exercise under the test for a worker, as to whether there is a contract in the first place. And Uber makes the important point that where one is talking about statutory employment protection rights, the approach one needs to adopt is one of statutory construction and not contractual interpretation. It's certainly not a pure law of contract matter. The contract is relevant, but is not the starting point, and it's merely one of the circumstances to be taken into account. My point for my lords is this, that the question whether a contract exists or not is not readily, or certainly not as readily susceptible to that kind of approach. It's a point that's been flagged in a recent decision of the Appeal Tribunal.
Sorry, to which kind of approach?
The approach of taking a purposive approach to the question of whether a person is a worker or not. The whole point of these statutory protection rights is to provide protection for vulnerable individuals at work. It is to ensure that people are, the inequality of bargaining as between employers and workers is evened out to some extent. And for that reason, Uber makes clear, the Supreme Court says that the submissions that Uber advanced, just look at the contract, there was undoubtedly a contract in Uber. The question was how to interpret it. Just look at the contract and interpret it. The Supreme Court said that was the wrong starting place.
But it was worse than that. The contractual documentation purported to show that there was no relationship between the drivers and Uber London Limited at all.
Yes.
That their only contractual relationship was with the Dutch company that owned the software and the app.
Yes.
And that was all a sham. But that doesn't help us in this sort of case. Nobody's saying that whatever one thinks of the code of conduct, so on, it's not a sham.
Quite so, my lord. Quite. All I'm trying to get at is, when asking oneself, does a contract exist? There is an element in which it's quite hard to dislodge, if you like, the common law principles. And I was going to try and offer my lord some submissions as to how the two might be married up. But can I just show my lord a reference in a decision of the EAT? It was on Judge Taylor on this occasion again. It's tab 37, page 850. A decision of October last year, a case of McLennan and British Psychological Society. And just as a matter of timing, this is decided after the EAT's decision. Now, this is October last year rather than May. Just to flag the key points from the headnote from our Lords, the claimant was a trustee of a charity and was elected to a role president-elect. And while in that role made 4 whistleblowing complaints. The result of all of that was that he was expelled from membership and terminated as trustee and president-elect, and he brought a whistleblowing claim, public interest disclosure of detriment. And the jurisdictional premise was that he should be a worker. And there was a preliminary hearing to decide whether he was or wasn't a worker, and it was found that he was not a worker. And on appeal to the Employment Appeals Tribunal, on the question of whether there was a contract or not, the EAT upheld the Employment Tribunal. But on the question of breach of human rights, because of the nature of the public interest disclosure claim, the EAT ruled that the Employment Tribunal hadn't reasoned it clearly enough and sent it back. But on this question about was there or wasn't there a contract in the first place between Mr. McLennan and the British Psychological Society, can I show my Lords just one paragraph in the judgment? It's page 863, paragraph 41. I can invite my Lords to read that, and then I'll make my submission about it. My point is that, as Zoologist Taylor identifies, there's an analytical difficulty of applying a purposive approach to the question of whether there's a contract between the parties, because ultimately one's concerned with the mutual intention of the parties. Did they intend to enter into a legally binding relationship, or another kind of legal relationship, or no legal relationship at all? And that's it to be answered, if you like, in light of well-established principles. But one understands that in the context of worker protection, employment tribunals aren't going to start and stop with any kind of a pure common law analysis. And what I was going to offer, my Lords, is this, that the way to try and bring the points together would be for employment tribunals to take a realistic approach to the question of the nature of the arrangements between the parties. In other words, a tribunal might be legitimately sceptical that an arrangement involving a large amount of money flowing in one direction did not involve a legal obligation in respect of that flow of money. But it would nonetheless taste the position. Whereas in an ordinary common law type dispute, a contractual dispute in the commercial court or otherwise, it might be that the court would be less sceptical in ordinary contractual principles of what the parties truly intended. But plainly, there's still scope for realism and contractual interpretation. All I'm getting at is there's perhaps a superadded level of, as it were, judicial mandated scepticism in the context of employment disputes, that it is quite often the case that people dress up arrangements as per Uber to look like something that they're not. And therefore, the tribunals need to be alert to that kind of thing. But let me see if I can help my Lords better with that submission in terms of going through the key bits in Uber that might explain it. I know my Lords are probably very familiar with this, but can I ask my Lords to turn that up? It's tab 27. page 452, if I may, take my lord straight to the relevant passage.
Did you say 442?
452, my lord.
452, thank you.
Paragraph 71. My lord will see here Lord Leggett explaining what the general purpose of the legislation is. You can see in the second sentence, to protect vulnerable workers and so forth. And then there's perhaps a helpful passage from my lords taken from Mr. Recorder Underhill as he was in Byrne Brothers and Baird, explaining what the policy behind the inclusion of Limb B was. And then if I may, my lords, when convenient, ask you to move to paragraph 76. So that's where Lord Leggett explains is once you've got clear in one's head that's the statutory purpose, it would be inconsistent to treat the terms of a written contract as the starting point in determining whether an individual falls within the definition of a worker. And then his lordship also says at D, the efficacy of protection would be seriously undermined if the putative employer could, by the way in which the relationship is characterised in the written contract, determine even prima facie whether or not the other party is to be classified as a worker. And if I can ask my lords to turn on a few pages, please, to paragraph 86. Actually, I should stop at paragraph 85, if I may, on page 456. Two points here to flag, if I may. That first of all, that the point picking up in the second line after the references to Carmichael and auto claims, and determining whether an individual is an employee or other worker, the approach endorsed in Carmichael is appropriate, even when there is a formal written agreement. And I'll come to Carmichael in a moment, but that's essentially looking at all the circumstances in the round and not simply confining oneself to the document. His lordship adds that between H and J, this doesn't mean that the terms of any written agreement should be ignored. The conduct of the parties and other evidence may show that the written terms were in fact understood and agreed to be a record, possibly an exclusive record of the parties' rights and obligations towards each other. But as he goes on to explain, there's no legal presumption that is so. And then lastly, over the page, the Lords at 457, paragraph 87, and coming back perhaps to what Lord Justice been suggested in the course of my submissions a little earlier, there's no substitute, as his Lordship says, quoting from Baroness Hill, for applying the words of the statute to the facts of the individual case. And applying the statutory language, it is necessary both to view the facts realistically and to keep in mind the purpose of the legislation. But what I was attempting to offer earlier, but perhaps I did it in the wrong order, was to submit that there is a way of bringing together this kind of analysis with the issue of asking oneself, is there a contract in the first place? Because the court or tribunal is entitled to ask itself whether the facts are such that it's inherently unlikely that work would be done, or this work of the kind in question would be done without a legal obligation to do it. or whether there's a perfectly legitimate and genuine explanation as to why the work's being done, which doesn't involve the analysis that there's a legal obligation that underlies the performance of it.
I may be being very slow, but are you saying anything more than Section 230 requires there to be a contract? In determining whether there's a contract, you look at all the circumstances, including anything that is put forward as having been the contract at the time. Full stop.
I'm doing two things, if I may, my lord. I am saying that one has to look at all the relevant circumstances, including the documentary material. But I'm partly trying to deal, as it were, by way of getting my retaliation in first, with a submission that my learned friend has made. This is a case which turns and turns only on the contents of the volunteer handbook, the code of conduct, and so forth. And it's simply a question of interpreting them on the premise that the document is contractual. One has to understand what it means. And it's the, if you like, the Davies debate, whether it's a Davies type case, the parties have agreed that all the terms of their dealings are to be contained in a document, and one doesn't need to look outside its four corners. Or whether it's a Carmichael case, and picking up my Lord Justice Stuart-Smith's question a moment ago, of looking at all the relevant circumstances, including but not limited to the document that the parties have used to record their relationship.
But it's your case, as I understand it, that all volunteers have agreed to abide by the terms in the code of conduct and the documents we've been looking at. Is that right?
Yes, my lord. When they sign up to be a CRO, they are agreeing to abide by the code of conduct. I accept that, my lord. But my submission is.
So those are the documents we're concerned with in the case. What other evidence about what they do or don't agree to do was there that supplements that?
Well, the other evidence there were witness statements from two individuals.
I know that, but what specifically was there that you say the Employment Tribunal was particularly able to take into account that the EAT was not? I mean, that's the point you're on ground one.
Yes, of course, my lord. And the answer to my lord.
What is there?
The answer to my lord's question is that the culture of the MCA, in terms of the way it's set up, that it has a relatively small pool of avowedly employed individuals and a much larger pool of CROs who are understood. First of all, there's an understanding as between CROs and the MCA generally, that the relationship is a voluntary one and not a contractual one. And that was a genuine understanding, because I'll come to the points in the judgment of Judge Cadney in a moment, but he tested in his analysis whether the treatment of the arrangements as voluntary was genuine or not. And he concluded and repeated this conclusion a number of times, that in his view, characterising these arrangements as voluntary was genuine. It wasn't an attempt to disguise or dress up something else as volunteering when the true analysis was that it was something else.
Depends what you mean by voluntary. Right.
Well, voluntary in the sense of without legal obligation.
But 2/3 of them took the pay for it. That still comes within your definition of someone who's doing it as a volunteer or voluntarily. I mean, as my lord says, one needs to be a little bit careful about whether you decide these cases by reference to a definition of what a volunteer is, which may mean all sorts of different things in all sorts of different contexts, and in terms of what voluntary means.
I accept that point, my lord.
And what was the finding of the Employment Tribunal judge, or the evidence he had on that, really something which informs the decision that has to be made as to whether it falls within section 230?
Well, I would say yes, my lord, and let me explain why. That at the Employment Tribunal, Mr. Groom's case was to argue that the, as it were, reality of the arrangements was contractual. He put it below in terms of an implied contract. That was the way it was argued. And from my Lord note, one will see that in the ET skeleton argument at page 113 of the supplementary bundle, paragraphs 3 and 6. But that's just by way of context. The tribunal, in analysing it, and let me show you my Lord's capacity. If I can ask you to turn in the core bundle to page 79. You can see, first of all, please, at paragraph 31A. He referred, first of all, to the nature of the agreement as voluntary agreement. And then he added this, and there is no suggestion that this is interpolating anything other than the genuine understanding of the respondent. Equally, he said, on the claimant's evidence, he too took the same view, at least from the commencement of the relationship until 2004 or 2005. And that was a reference to the fact that Mr. Groom had changed his mind about the nature of his relationship with the MCA.
The judge was concerned with whether he was a worker at the time that he wanted to have a union representative. So it's post 2004, 2005, isn't it? All that tells you is that one side at that stage would have described it as voluntary and he wouldn't.
Quite similar, but the point that...
How does that inform the decision that has to be made? I don't really understand that.
The way that gets reflected, my Lord, is in the paragraph 34. He picks that point up again. I'm going to come back, if I may, to 32. But at 34, foot of page 79, at top of page 80. He makes 2 points. First, he says, if both parties in starting the relationship genuinely believe it to be voluntary, then that is powerful evidence that that is precisely what it is. And secondly...
Sorry, but pausing there, if at the relevant time one side believes it to be voluntary and the other side doesn't, how does the fact that they took a different view at an earlier time help to inform the decision?
Well, it's because, as the judge points out, that there was nothing by way of evidence to explain how the fundamental nature of the relationship could have changed as between the parties from those first 20 years of the parties, those first 15 years of the parties working together to the latter period of the parties working together.
This rather reflects the fact that whether you describe something as voluntary or not is a rather subjective view.
It can't be, the answer can't depend on what the individual coastguard thought was the nature of the relationship.
No.
Otherwise we are wasting both sides' time and money here.
No, I accept, of course, I accept that, my Lord. The point that the judge was simply making, as I understand these two sentences taken together, is nothing changed in terms of the observable features of the relationship in the period as a whole. And yet, for a substantial part of it, both parties found it acceptable to regard the relationship as non-contractual. I do take my Lord's point that it can't be a matter of the subjective perception of one party. Otherwise, as my Lord says, all we're deciding is Mr. Groom's case and not making any useful analysis of the position as a whole. But I was simply trying to get at the question that my Lord Justice Popplewell raised about what was it in the employment judge's analysis beyond the documents that led him to the view that he took. And then the other 2 points that I wanted to show, my Lords, were these. Paragraph 34, I'll show my Lords one reference, there's a second one. I'm sorry, I've shown my Lord's paragraph 34 already. Paragraph 35 is really just the conclusion that he reaches, that he was satisfied that the agreement was genuinely voluntary. Now, I do take my Lord Justice Popplewell's point. It depends what one means by voluntary. The bit that I'm emphasising, if I may, is the genuineness of it. In other words, what Judge Cadney was expressing, the point having been raised with him in the argument on behalf of Mr. Groom, was that this was not window dressing of purporting to treat as non-contractual that which on a true analysis was contractual. In other words, it wasn't like Uber of dressing up as a contract between the driver and the Dutch company. Or
I understand that submission, but that seems to undermine your point on ground one. That would suggest that we can look at the document reflecting the true position and decide what the position is on the basis that the documentation does, in our case, reflect the true position, and that was the position that the tribunal judge and the EAT could take, whereas the basis of your ground one seems to be, the Employment Tribunal had a greater advantage because it was able to take into account a lot of factual evidence about what happened on the ground, which gave it an advantage over simply looking at the contractual documentation or non-contractual documentation, but the documentation.
Yes, I mean, the overlay, my lord, is this now. I would say that there isn't a tension. Let me explain why. It's not a question of attempting to disavow or distance myself from the contents of the document. I'm simply trying to locate them in the right place in the analysis. But the documents are not the start point and the end point of the analysis. One does have to have regard to the wider context of the relationship, the structure within the MCA, and the, if you like, history of established dealings between the MCA and all the CROs, of whom Mr. Groom was merely, in this respect, an example. It's not that, if you like, that this was a bespoke arrangement, which one might question.
Well, that's clear from the documentation.
I understand my lord's point, but the danger, as I see it, and I'm probably segueing into a different point here, the danger as I see it is one treats the documents as though they were a contract, and then one interprets them as though they were a contract. Whereas the true question is whether the documents reflect an intention to enter into a contract in the first place. It is a different question in my submission, but I'm conscious that I'm segueing from one point to another, and I apologise for doing that, but it's important in my submission just to locate my submissions about the documents within the overall argument. But what I was attempting to do, my lords, was to indicate that in the context of statutory employment rights governed by the definition of a worker, a tribunal is entitled, if not obliged, to determine whether arrangements which the parties have characterised as, just to use the word for the moment, my lord, volunteering, are truly non-contractual, or whether it's a disguise or a dressing up exercise to avoid the imposition of statutory obligations which would otherwise arise. That's a relevant consideration in my submission, and that's what this employment judge did do. So the second subject matter I wanted to address under this head is what is the analytical exercise in ascertaining the existence of a contract and separately its terms, because it may not be the same exercise. And obviously in some cases there'll be no issue that there's a contract in existence and the dispute is simply what are its terms, classic battle of the forms or no forms case. In other cases it'll also be very straightforward because there's no dispute that the parties have intended to enter into legal relations. But there is this important dichotomy in the cases between a scenario where the parties intend a document to be, as it was put in Carmichael, the exclusive memorial of their relationship, and that's the language of Lord Irwin. And that's referring to Davis and Presbyterian Church, or whether the purview of the court or tribunal deciding the matter has to be wider. Let me, if I may, just show my lord the passages in Carmichael which flag the point. It's at tab 9 of my lord's authorities binding. That's page 161.
Page
161, my lord.
Thank you.
That's the head note. This is the case of the tour guides at a power station in Blythe. And they've been engaged to work on a casual as required basis. And just to emphasise from the very outset, that the case was about whether these individuals had a statutory right to employment particulars. And the case was put, and only put, in terms that the entire relationship was contractual. And there was not a separate argument that when they provided a guide on any particular occasion, that there was a contract in place for that occasion. In other words, the argument was issued, the argument took place purely on the issue of overarching or framework contract, and not at all on the basis of job-by-job contracts. And both substantive speeches make that point. But if I can show my Lord the passages in, first of all, in Lord Irvin's speech.
And they were saying not just we're workers, they're saying we're employees.
Quite so, my Lord. It was employment under a contract of employment was what was being said. And what was being said, that there was a contract of employment throughout the relationship, not merely on the occasions when they did work. If I can invite my Lords to look in the bundle at page 164, my Lords will see at the top of the page that the well-worn phrase, it may have come from somewhere else first, but it started with the Industrial Tribunal in terms of legal reporting, that the claim foundered on the rock of the absence of mutuality, because when they were not working as guides, they were in no contractual relationship of any kind with the Electricity Board. And then just picking up the words at B, which are important later because Lord Irvin refers back to them. He says the tribunal made this finding on the basis of A, the language of the document, B, the way in which it had been operated, and C, the evidence of the parties as to how it had been understood. And he says, for reasons I amplify later, that was the correct approach. And then I should draw my Lord's attention at 164G. I won't read the passage out, but his Lordship says if the matter had been to be determined solely by reference to the documentation, he still wouldn't have been persuaded. But he goes on to explain what he says was the correct approach at bundle page 165. He repeats his point about the effect of the documents at D. He says, if the appeal had turned exclusively, and in my judgment it does not, on the true meaning and effect of the documents, then I would hold. But it's the point of approach that I wanted to emphasise for now, my Lord. So it's in the next paragraph. If I might invite my Lord to read the paragraph beginning in my judgment down to its conclusion. And then there's a similar passage in. With apologies, if I can just ask my Lord to note at the top of page 166 of the bundle, where Lord Irvin brings this part of his analysis to a conclusion, where he says, the first sentence that appears at the top of the page, that the tribunal was well entitled to infer from the documents the surrounding circumstances and how the parties had conducted themselves subsequently, what their intentions were. And just for my Lord's note, you see his Lordship repeat here at the end of the paragraph, no issue arises as to their status when actually working as guides, because that wasn't how the case had been put. And then there's a similar passage put rather differently in Lord Hoffman's speech. If I can invite my Lords to look at the section starting at the very foot of this page, 166. There's a quotation from Lord Devlin's lecture, Trial by Jury. 2 types of questions of law. And the second type is questions of fact, which lawyers have decided that judges can answer better than juries. And Lord Hoffman observes that that includes the construction of documents in their natural and ordinary meaning. And goes on to explain, with reference to Davies and Presbyterian Church, that the interpretation of a contract of employment or a putative contract of employment can be an issue of law. And he concludes at the end of this paragraph that the rule, the construction of documents as a question of law, was well established when industrial tribunals were created and has been carried over into employment law. But it's the next paragraph which I would particularly like to emphasise, because in the course of the proceedings in Carmichael, the Court of Appeal had decided that the documents were the exclusive memorial of the parties' relationship, and that all one had to do was interpret the documents. And Lord Hoffman says between E and G that the Court of Appeal pushed the rule too far. It makes it clear that it applies in all cases where the parties intend all the terms of their contract, apart from implication, to be contained in a document or documents. It doesn't apply when the intention of the parties objectively ascertained has to be gathered partly from documents, but also from oral exchanges and conduct. In the latter case, the terms of the contract are a question of fact. And it's also the case that whether the parties intended their document to be an exclusive record is also a question of fact. So the submission I'm seeking to make to my lords is that this was not treated in the Employment Tribunal as a Davies type case, where it was purely a matter of interpreting the code of conduct and the handbook and nothing else, and that the employment judge had proper regard to the context in which those documents came into being as between the MCA and any CRO, that the premise of the work that the individuals were doing was a form of public service rather than akin to employment.
What about the remuneration document?
Yes, I'm obviously going to deal with the remuneration document, of course, my lord. But what the only...
Sorry, you've shown us the findings of the Employment Tribunal judge about the views of the parties as to whether it was voluntary or not. But what other findings of fact are there that help us on that? Of matters that fall outside the scope of the documentation.
Let me find the relevant passages from my lord. In terms of the arrangements and the question of obligation,
I mean, there's paragraph 13 which deals with 1/3 don't claim remuneration, and that of that 1/3 their reasons vary, some because they don't think it's consistent with their voluntary public service ethos, others that the tax implications make it unduly onerous or not worthwhile doing so. So that is, you can fairly say, finding about what happens in practice as opposed to what's on the documents.
yes, I mean, this part of the judgment, I suppose, my lord, just taking it in order, starts at 10, under the heading training attendance. You can see that there's a reference to the document in the Code of Conduct, and picking it about halfway down the paragraph, there is a dispute about the meaning of reasonable levels of attendance. Mr. Misen's evidence was that there was no national standard, whereas the claimant insisted that there was. And then he goes on at the top of the next page. He says, despite this evidence, I believe there's a typo there, a repetition of this, which I accept. And that passage concludes with the sentence at the end of paragraph 10. Both, referring to Mr. Myers and Ms. Daly-Lees, have given evidence which is not disputed that a reasonable level of attendance was necessary to maintain skills and the perception that all members of the team were pulling their weight. And then at paragraph 12, on beginning remuneration, there's a finding as to the purpose of the remuneration system. He quotes from the document as to that it's to cover, 4 lines down, to cover minor costs caused by your volunteering and to compensate for any disruption to your personal life and employment and for unsocial hours, call-outs. And then the point my Lord made at paragraph 13 about proportions. There was reliance on views expressed at national conferences going back to 2004-2005, paragraph 14. And then there was evidence at paragraph 15 which the judge accepted that those expressions of opinion hadn't been ultimately accepted or acted on. He refers to the HMRC NNW investigation at paragraph 17 and its conclusion at 18 and 19. And then the passages I also wanted to find from my Lord with apologies for not starting in the right place. It's in the section of, it's in the, as it were, analysis section, conclusions. Starts on page 78.
78.
78, but the 2 references I was looking for. Is it paragraph 33, my Lord, it may be slightly out of order, but in response to my Lord's question, that he concludes 4 lines down that the reasoning in Grayson does apply, and I'll come back to Grayson. But it's the point that he makes in the next sentence. Whilst a sense of public service might compel a CRO to continue to assist in activity, particularly one in which there's a risk to health and safety of members of the public, there is no contractual right on the part of the respondent to require them to do so. And then the point that's made by the claimant is that the respondent could in those circumstances ultimately terminate the membership, which he contends is the equivalent of a contractual right. The judge concludes, as a matter of fact, there is no contractual right to take any action at all. I appreciate, my Lords, there's a...
Well, that's conclusion rather than findings on evidence, isn't it, really?
Yes, I accept that.
Thank you, I found that helpful.
As a matter of fact, there is no contractual right to take any action at all.
I mean, it may be, as Lord Justice Popplewell observed, it's an expression of a conclusion, as it were. If one starts from the premise that there isn't a contract, then there's no contractual rights under it. But in my submission, what the judge was getting at in this passage, in terms of the analysis and locating it within Grayson, to which I'll come, it is that there is a reason for the CROs to behave as they do, which doesn't involve the analysis that there is a legal obligation on them to do it. And therefore, it follows that any response that the MCA might make to an individual where there was a problem with their membership is not an expression of a contractual right at all.
Can I just, have I got that right? There's a reason why CROs behave as they do, which is not dependent on the existence of a contractual obligation to do so.
Yes, but that's what I said. Yes. It's the sense of public service point. Is it where it's?
It may or may not be. You don't have any findings to that effect. What you do have is the evidence that 2/3 of them take the money, which some might say is not entirely consistent with them being solely driven by a sense of public service. I mean, you have the evidence and you have the findings that you have.
Yes.
That is, they don't go as far as saying the reason people do this is because they're solely motivated by a sense of public service. Is that fair?
That is fair, my lord. That isn't recorded the only reason or the predominant reason that they do it. I accept that point, my lord.
I don't doubt what you say is true, but I don't see what its legal significance is. Many people, for example, are nurses or entry-level teachers whose talents would enable them to have far better paid jobs, but out of a sense of public service, they take the lower paid job and do good, but they're still employees. Of course they are. I'm not sure that motivation has got much to do with it.
Well, I understand there's a danger with a word like motivation, my lord, because it is loose. But what I was trying to convey is the point when one looks at a relationship in which there is an element of remuneration, as my Lord Justice Popplewell has identified, an explanation for that may be that there is a contractual obligation to provide work and a correlative obligation to pay for it. Another explanation may be, and this is the MCA's case, is there isn't a contractual obligation to provide the work, but there is a response by the MCA to its volunteers, to the CROs, let me be clear, to the CROs, which is to compensate them for the disruption to their daily lives, but which is not intended to be a wage.
And it's not. Your case is it's not contractual. It is an offer to pay that sum, but it's not an enforceable legal offer. It's binding in honour only.
I say that, my lord. That's the primary submission I make. My alternative submission as to that is, even if there is a promise to pay that remuneration, it doesn't find its correlation in an obligation on the part of the individual, CRO, to do the work. A legal obligation on the part of the CRO to do the work. And that's what matters for the purposes of the analysis and the definition of worker. There must be a contract whereby the individual undertakes to do or perform work.
But the consideration, if it is a contractual promise to pay the remuneration, the consideration for it is simply the detriment of performing the work rather than an obligation to perform the work. Is that how you put it? I mean, something which is an enforceable obligation to pay can only be contractual if consideration is given for it. It's mutual obligation,
yes.
Usually.
Yes, quite so. Quite similar.
But your alternative case is there can be a contractual obligation to pay the remuneration without any concomitant contractual obligations on the CRO.
Quite similar. I mean,
if that be right, where does the consideration come for the agency's promise to pay?
So the consideration comes on that premise, my lord, in the form of a unilateral contract, whereby if you turn up, we will pay. So that it's the Grayson analysis of Mr. Justice Reimer that there is no obligation at any stage in that analysis on the individual to do the work. And so the contract is not of the right type. There is a contract, but it's not one of the right type. Because it's not a contract whereby the individual undertakes to do work or perform services. In answer to my lord's question, there's consideration because the individual has turned up. And so maybe my lord, as the way my lord puts it, is right, that it's the detriment to the individual's time that would otherwise have been available to them for other purposes. They've given up and they've suffered a detriment in that sense.
Thank you.
You're not obliged to turn up for work or to take me to York, but if you take me to York, I'll pay you X. It's a contractual arrangement of that. It's an arrangement of that kind. If you take me to York or if you turn up for work, then in consideration of you having done that, we will pay you.
Sorry, I'm not thinking about that for a few seconds, but yes, I accept the way my lord puts it.
That's your unilateral contract.
Quite so. I mean, I've taken myself out of order, and it's not my lord's fault. But it's just the Grayson analysis offers that as a legal solution to the problem of how one applies the definition of a worker in the context of Citizens Advice Bureau volunteers. And I appreciate everything my lords have said about using the word volunteers, but that was the word from those cases. And the test one's trying to ascertain is whether the test one's trying to apply is whether the parties intended to enter into legal relations.
Well, that's very far-reaching submissions, it seems to me. They'll no doubt take us to Grayson in a moment. And as I recall, CAB volunteers in Grayson were unpaid. But are you saying that if there is no obligation ever to turn up, but there is a promise by the organisation to pay at a certain rate if you do turn up, that there is no, the people who turn up are not workers? I mean, suppose you have, say, I don't know, a building site, and the terms of business are that you don't ever have to turn up. If you turn up and ask, is there work for me? Answer yes. £15 an hour or whatever it is, you can start now. But if you don't want to come, you don't have to come. Surely that person is a worker.
I accept the point, my lord, but the reason why it's right is because there's a set of mutual obligations at the point at which the individual turns up for the work. So having, as it were, attended to do the work on the building site, there is now a contract for that assignment. And so the individual is undertaking to do the work at that point. The fact that he didn't accept the obligation until he turned up at the building site is nothing to the point. See PG Mole, see Somerville. What matters is that he's under a legal obligation when he does turn up.
Well, then the critical distinction you're making is that the Coast Guard put aside the rope being to the man halfway down the cliff, but just when it's not quite as critical as that at least in all other circumstances, the Coast Guard can walk off the job.
The CRO, yes.
Yeah. And that's the difference between that and the building site worker. But supposing the building site worker is told £15 an hour, starting at 9 o'clock, when you're fed up, you can push off and go home. You say not a worker.
Well, I appreciate my lord's formulation of that fact pattern. If there is a contract whose terms are, you will be paid £15 an hour for every hour that you do, but you are free to cancel at any time. If that's the analysis of the contract, then the fact that the individual is walking off is an expression of his contractual right to walk off.
Yes, but say maybe nothing in writing. Section 230 says contract, whether express or implied, whether oral or in writing. But the fact that you don't have to turn up if you don't want to, and you can walk off the job whenever you feel like it, obviously only being paid up to the moment you walk off. Doesn't stop you being a worker within section 230, does it?
Well, if those were the terms of the contractual arrangement, and I'm deliberately emphasising that one's determined that it's a contractual arrangement, then I agree, my lord, that while the work is being done pursuant to a contractual obligation, the individual is a worker, and it wouldn't matter that he had the contractual right to cut short the services that he'd agreed to provide. So he'd signed up for an 8-hour shift, but he has a contractual right to walk away at 4 hours, for example, to keep it as simple as possible. The fact that he does exercise that right and walks off after 4 hours doesn't negate the fact that he was a worker for that shift of 4 hours. I take my lord's point.
Can I just ask, we've been focusing slightly on what happens when someone's called to an incident, but before you get to that stage, can I ask how the system works in terms of detecting an incident that needs responding to? Presumably there are people who man phones, are there?
Well, I mean, there would be a call to the emergency services. Well, somebody would dial 999.
Yes,
And then
that then goes through to the Coast Guard.
Yes.
Are the people manning the phones at the Coast Guard end, are they employees or are they?
No, they're the
volunteers?
they're the employed
They're all
staff
employees.
of the MCA.
And presumably also sometimes they're alerted to incidents by people banging on the window of the Coast Guard stations and so on and saying, look, there's someone who looks as though they're going to be caught by the tide or whatever it may be.
Of course.
Are those all manned by permanent staff or are they station officers?
Some of those local stations are staffed by either CROs or their, as it were, their more senior equivalent, which was Mr. Groom.
Right. So say you have one. I mean, I've seen one in Norfolk, which typically would have one person there who the public can alert. I don't know whether they'd be a CRO or a station officer, but it doesn't really matter. They're free, are they, at any stage just to shut the door and go home and abandon it?
Well,
Never mind whether it's contractual or not, but in terms of what they've agreed to do, haven't they agreed to stay there for the time that there's going to be their, whatever it is, their shift, if you want to call it that?
Well, I want to make two responses to my lord's point. One is, I haven't actually got the evidence about what that scenario would involve, and so there's a danger of my speculating.
Well,
but let me answer my lord's point as a matter of principle,
Yeah.
and then with the reservation that I'm doing so, if you like, without a factual foundation for it. My understanding of the position is the same, that the station officer would not be in breach of any contractual obligation owed to the MCA because there isn't a contract to do what he does in the first place.
I understand that.
It may not be regarded as tremendously acceptable, my lord, particularly if there's a storm at sea and it's actually quite important to keep a lookout.
But I'm back to the point I was on earlier. Leave aside whether it's contractual or not. Is it something stopping doing something which he has agreed to do, undertaken to do in the lay sense, whether that's even assuming it's a non-contractual undertaking? It's another example of whether someone can walk off the job. And you said, in answer to my lord, well, it's not as though someone's agreed to do a shift. We're not in that situation, but there may be cases which are quite analogous to someone who's agreed to do a shift.
Well, I suppose one has to interpolate facts which we don't have. I mean, I suppose, my lord, if somebody is asked to staff one of those stations over certain hours and agrees to do it, then it may be that that is the arrangement that's been entered into, that the arrangement is that he will be there during those hours. The arrangement might be characterised differently. It might be we need somebody to staff that station for as long as possible. Any volunteers, somebody volunteers, but they're free, they're perfectly free to leave because they can't stay any longer. They've got demands at home or demands at their regular job. The danger of my lord's question, and it's not my lord's question's fault, is that we haven't got the factual foundation to test what the factual parameters of that scenario would be. But the principle, I would say, my lord, is that in the whole overlay of this arrangement, as it was explained in the evidence of Mr. Misen, is that none of these CROs or the station officers are under a contractual obligation to the MCA to do anything. it's all a matter of expectation and understanding. People do what they do because they want to do it, and I acknowledge the point about motivation, but they are free to stop doing it
I understand.
should they wish to stop doing it on any particular occasion.
Probably it's the same line. You have to establish that Mr. Groom or ACR is a volunteer in the sense that there is no contractual obligation or undertaking to carry out the work. Because if there's a contractual obligation pursuant to which you undertake to carry out the work, you're snookered. You lose because you're within 230.
I accept that promise.
So, you have to establish that the person is a volunteer in the sense that there's no contractual obligation pursuant to which you undertake to carry out the work. But, in fact, the CRO does carry out the work, not pursuant to a contractual obligation. The flip side of that must be that accordingly the payment they receive must not be contractual consideration for undertaking to do the work.
That's right, it's gratuitous.
Even if it is either consideration for having done the work, which is one possible analysis, or is payment pursuant to a non-contractual obligation. Because you could have a situation where you have a genuine, I'm going to use volunteer setup, but the person who's in your client's position says, well, we can afford to pay you something if you do this, and we will. Not as a matter of contractual obligation, but we will. And it seems to me that you're aiming for that safe haven. You're trying, because you've got to establish that you're not within section 230. The corollary of that is that the payment is either non-contractual, which is conceptually possible, or if it's contractual at all, is a payment for having done the work, which wouldn't then bring you, or would arguably not bring you within section 230.
That's right, my lord. That's right, my lord. I don't shy away from, sorry, I apologise, I didn't mean to interrupt.
I'm just struggling to see how this analysis works. Because speaking entirely for myself, not just for the Coast Guard, but across the range, I find it easy to conceive of circumstances where a payment is made which is non-contractual and does not give rise to someone coming within 230. If the whole shebang, it doesn't matter whether it's flower ladies at a church or people doing this, volunteering at a National Trust property or whatever it could be, I can conceive of a setup where it is a voluntary setup, which is what you're contending for. And speaking again entirely for myself, I do not see the fact that a payment is made, even if it is made by reference to the time spent at volunteering work. It does not create a contractual obligation that brings you within section 230. But I'm finding this very difficult, as my last minute probably demonstrates. But is that where you're heading for as a matter of analysis?
So there's two prongs, as it were, to the analysis. One is that nothing that takes place between the CRO and the MCA is contractual at all. And on that premise, the payments that are made are non-contractual and gratuitous, and the individual would not have a right to sue if payment were not made.
And that's acceptable. Do you say that's an acceptable view or the right view of what was going on?
I would say it's both acceptable and right. Obviously, I would acknowledge, my lord, if that the MCA made a practice of that, it would be likely to find a significant reduction in the number of its CROs. Both people might leave and people might not sign up in the first place, because there's an element of trust in a relationship of this kind. If one has a scenario, as my lord outlined it, if you do this, I will do that. It's not a promise in a contractual sense, but I am saying that I will do it. If you don't do it, what you said you will do, the other person is less likely to trust you the next time.
Go out the door.
So that I acknowledge,
Going back to what you said before about consequences and sanctions, the consequence may be that people just go out the door.
quite similar, but the cases are replete, if I may, with examples of how what's sometimes described as market forces explain why people behave as they do, like Trust House Kelly and Trust House 40 and Trust House, where the issue is whether the casual waiting staff turn up over and over again because they're under an obligation to keep turning up, or whether they do it because there's an element of market forces which encourages them to keep coming back. I appreciate that the analogy here is not quite market forces. It's a question of public-spirited desire on the part of the CROs to assist the MCA, and then the MCA discharging its functions with the benefit of the assistance of the CROs. But the point, my lord, is this, that one doesn't have to look for contractual rights and obligations to explain legitimately and properly why things occur as they do. And so my lord's point, people might leave, of course they might. And that's a reason why the MCA goes on doing what it's said to do, rather than because it's under a contractual obligation to do it. I don't shy away from the proposition that if a payment wasn't made on a particular occasion, even though the MCA had said it would make it, it would not be a breach of contract not to pay it.
It might have severe adverse consequences, but not a claim for damages.
Yes. The alternative way I put my case, my lord, is that, and I appreciate I'm going to need to explain Grayson better in order to get there, but the alternative way I put it on the basis of Grayson is that in that analysis, whereby the MCA says, if you turn up, we will pay you, and one treats that as though it were a unilateral contract. If you do that, we will do this. Still isn't the kind of contract that comes within the scope of section 230, because a contract must be one under which the individual undertakes to do work. And there is never a point in the analysis where he undertakes to do the work. He does it, but that's not what's required under the section. It's not drafted in terms whereby the individual does work or perform services personally. It's whereby the individual undertakes to do or perform work or services personally. The personally I put in the wrong place there, but my lords have the point. What matters is the promise to do the work. Rather, obviously the work has to be done in order for any right to be generated. But my point is, to be a worker in the first place, there has to be a promise. And going back to the submissions I was making earlier to my Lord Justice Popplewell, it has to be a contractual promise.
But there's nothing in the remuneration document to say if you do make a claim, it's still up to us whether we pay it or not. Is there?
There wouldn't be, because there's what's being contended for is a non-contractual obligation. It's not up to us whether we pay, except in a physical control sense.
Well, there's a passage in the handbook that, if I may, my lord, may I say, so if I can just pick that up for my lord while we're dealing with this subject matter. So it's about the question of payment. My lord will find it in supplementary bundle page 22. That's tab 3, I believe. And it's under the heading payment.
Yes.
You can submit monthly claims if you wish. The money is to cover minor costs caused by your volunteering and to compensate for any disruption to your personal life and employment and so on.
Yeah.
And then the remuneration document gives details about what's covered and what isn't.
And I think there's another passage that says it's to compensate for your time, isn't there?
Yeah. Just compensate for any disruption to your personal life and employment and for unsocial hours. There's nothing saying you've got no right to payment, and if we choose not to pay you, that's your bad luck.
Well, the entire premise of it all, my lords, in the introduction to the handbook. It puts it in terms, my lords will see in the penultimate paragraph there on page 12. It's clear policies and procedures about what we, the MCA, expect from you, the CRO, and equally important, what you can expect from us. It's expectations rather than entitlements and obligations.
We also have to have regard to the document at page 1, don't we? Which is the one that deals specifically with remuneration. Not obliged to claim, but wish to claim remuneration for time. I mean, that is a classic description of what a wage is. This is what you have, and then introduction. CROs will need to understand the different categories of activity that will attract remuneration. It's not expressed in discretionary terms, is it? And then you get the various different categories, and you get some very detailed rules about how they're to be calculated in terms of category A, for example. You get a minimum of 3 hours, and then it deals with what happens if it doesn't, and so on. Really quite detailed rules. I quite understand your overarching point is if this isn't contractual, it's not contractual. But insofar as one can use the documents to see whether the parties regard it as giving rise to an obligation as opposed to a discretion, there are certainly these aspects of the documents that look more like an obligation than a discretion.
The way my lord puts it is fair, if I may say so. The response I would offer to my lord is this, that this is an explanation of the administrative arrangements of how remuneration will be dealt with. It is explaining what's covered and what's not. It sets out in the language of the introduction to the handbook what CROs can expect from the MCA. But my point, again, perhaps I'm merely repeating myself, is that although it's expressed in terms of these parameters of what will be in and what will be out and the way claims will be dealt with, none of it is contractual because it's all subject to the overlay that the whole arrangement is non-contractual.
Or this is a unilateral contract where these payments are consideration for the work that has been done.
Quite so, but at no point is there an obligation undertaken to do it.
That fits more comfortably with the terms of the document. Maybe.
Well, yes, I mean, the claim can only be made after the individual has turned up. The individual doesn't put in his or her claim.
Of course not.
While we're dealing with this subject, can I try and isolate, if I may say so, a striking example of where the EAT got the balance wrong and the Employment Tribunal got it right. So that in terms of the language in the introduction to the handbook, there's one particular phrase that is picked up by the EAT in my submission unfairly. So if I can ask my lord to look at page 12, again, the introduction to the handbook, and the paragraph beginning the relationship between the MCA and its Coastguard Rescue Service volunteers is a voluntary two-way commitment where no contract of employment exists. That language.
Yes.
And so this question of what does a voluntary two-way commitment involve is something that the Appeal Tribunal picked up on. And you can see the way it's dealt with at paragraph 112 of the decision below, it's called under page 57. See that passage quoted 4 lines down into the 5th line of paragraph 112, and the deputy judge says there that that expression does not expressly negative the existence of any contract, let alone, nor even a worker contract. The phrase two-way commitment is indicative of some form of mutual obligations, and then the paragraph goes on to deal with a somewhat different point. But my submission is that that approach to the language of two-way commitment in the introduction is unfair, because if one looks at the handbook as a whole, there is a passage that explains in much more detail what the word commitment is doing in the document. If I can ask my Lord to see supplementary bundle page 17. There's a heading of the volunteer commitment. I may have shown my Lords this earlier on a different point, but one sees that the introductory part of this page explains that membership of the CRS is entirely voluntary. That means in formal language, there's no mutuality of obligation. The commitment aims to make sure that the relationship works for everyone. And then what HM Coastguard will do, and in return what HM Coastguard asks the individual to do. So the point I wanted to flag was that the two-way commitment that's being referred to in the introduction is plainly this volunteer commitment. What is being said on this page about what the MCA will do or HM Coastguard will do, and what it is that in return the CRO is asked to do.
Well, no, I would read no mutuality of obligation, meaning you don't have to turn up if you don't want to, ever. We don't have to call you out if ever. There's no obligation to provide X hours work per month or something. But to say it means we don't have to pay you if you do is quite a major step forward.
Well, in my submission, what it means in the context of this document as a whole is neither of us owe contractual obligations to the other. This is what we're saying we will do for you as a CRO, and this is what we ask you as a CRO to do for us. But none of this amounts to a contractual promise at all.
What is the content of the commitment which the volunteer commits to? I know you say it's non-contractual commitment, but what is its content? What is the volunteer committing to do, i.e. promising to do?
My Lord sees it in the 4 bullet points at the foot of the page.
So those are commitments. That they are matters that the volunteer is undertaking to do, although you say not in a contractual sense.
Yes. But the point is taking what the learned deputy judge said below, that a two-way commitment is redolent of mutual obligations, in my submission is unfair in circumstances where the volunteer commitment is expressly said not to involve mutual obligations. Because it says so on the very page that's talking about the volunteer commitment.
But if we take the 3rd bullet point, comply with all instructions and procedures that apply to CRS activities,
yes,
that's quite a catch-all, which really means doing what a CRO has to do. So if we reach that stage, it's common ground that is something that the CRO undertakes to do using that in lay language, and it's simply a question of whether that undertaking has any legal content. Is that where we've got to? Because that's quite a long way from, I think, where we started the morning, which is the CRO's don't really agree to do anything. They can walk away at any time.
Well, I'm not.
Contractually.
My lord, I wouldn't accept that it's quite a long way from where we started, because it's always been my submission that whatever is the party's understanding of what each will do for the other, none of it is founded on contract.
Well, I understand that, but in order to test the reality or the consequences of that, we've got to start by looking at what each does agree to do for the other.
Yes.
And I had thought, perhaps I misunderstood that earlier this morning you were saying that really the CRO doesn't undertake, even in a lay sense, to do things. They can always stop at any stage and say no.
That's right, Lord. At no point is the CRO undertaking to do work. What this is saying, and the point that my lord is emphasising here on the third bullet point, is if he does turn up, he will have to regulate his behaviour in accordance with what's required of the CRO. But he's not obliged to be there. If he is there, he's not obliged to stay there, is my submission about the understanding of the parties as to what the relationship involves. There isn't an obligation to do the work. But if, having turned up to do the work, you are accepting certain requirements about how the work should be done, that's the control point. But the reason that there are those parameters about how the work should be done is because of the safety critical nature of the work. And it's not, as the judge found at first instance and hasn't ended up in the Court of Appeal, not a factor that helps one to decide.
Maybe that one can't really draw a bright line between the how and the whether if you're in the grip of an incident.
Well, there's obviously a whether question of whether somebody responds to a call out in the first place at all. But I accept, my lord, that there doesn't have to be an antecedent obligation to work for there to be a worker contract when somebody does work. So I accept that only takes one so far. The point is that when somebody does respond to a call out, the question is, for how long must they continue? Are they under any obligation to continue at all? And if so, for how long?
It's my fault. I've taken you back over old ground.
No, not at all.
I understand how you put it.
It's nobody's fault, my lord. I'm conscious of the time. Just before the break, can I just show my lords two references? I think I can do that quite quickly. They both arise in a different type of context, where the issue is whether the source, there is an obligation, but the source of obligation is not a contract. So let me show my lords two slightly different cases on the same point. There's a case at tab 21, Preston, page 356. Preston, president of the Methodist Conference. And so the issue is essentially here whether a church minister was working under a contract. I should emphasise that the claim was for unfair dismissal, and therefore that what mattered is that the individual had a contract of employment, properly
Yes.
so called. And that the ultimate conclusion was that there wasn't a contract. That was the decision of the Supreme Court, Baroness Hill dissenting. If I can show my lords the key passage on this point, it's at 371 in the judgment of Lord Sanction. Paragraph 26. The reference to Percy's case was a previous decision, as my lords will probably know, of the Supreme Court, concluding that a church minister could have a contract of employment, but there wasn't any general rule or presumption against that proposition. But his lordship says, picking it up at the fourth line, if I can invite my lords to read from there, the question whether an arrangement is a legally binding contract. Down, if I may, just to the sentence between G and H, which ends, ministers must be interpreted. So just the expression of principle that His Lordship explains there. On the question of whether there's the intention, one looks at the overall position, and one is entitled to have regard to the nature of the work being done here, the spiritual character of the ministry, because that's a significant part of the background against which the overt arrangements must be interpreted, as His Lordship puts it. And then over the page. Sorry, I apologize. Just the way that this is appearing on my screen. I apologize. Just at the end of the page 371, there's a sentence that begins: "The correct approach is to examine the rules and practices and any special arrangements made." And then, paraphrasing what Lord Nichols had said in Percy, the arrangements properly examined might well prove to be inconsistent with contractual intention, even though there was no presumption to that effect. And then the same point features, if I can ask you to turn to tab 25, page 407, the case of Gillam and Ministry of Justice. And this is the case involving a district judge, quite well known, who brought proceedings against the Ministry of Justice complaining of detriment for making a public interest disclosure. And in the outcome, there were two issues: whether District Judge Gillam was a worker. The answer, no. But whether her human rights were unlawfully interfered with because she couldn't make a claim of public interest disclosure. Answer, yes. On the, if you like, question of whether there was a contract, can I ask you to see at page 414? This is the judgment of Baroness Hale.
She was held to be an office holder.
That's right, the district judge was an office holder, but there wasn't a contract.
No.
There wasn't a contract. That's why I said, by way of overview explanation of these two cases, that there were different sources of obligation. There were obligations, but they were non-contractual sources for them. So the point in Gillam at 16, but just above at 15, your lordships can see that although Baroness Hill acknowledges her dissent in Preston, she makes clear that she wasn't dissenting on the principle, she's dissenting on the application. She says that in the last sentence of paragraph 15. And so at 16, she emphasises the question: did the parties intend to enter into a contractual relationship? And then she says, in answering the question, it's necessary to look at the manner of engagement, the source and character of the rules, and the overall context. This is not an exhaustive list. But my point of showing, my lords, these cases in this somewhat hurried way is just to tie together the Carmichael type analysis on what is involved in deciding whether there is a contract of employment or a worker contract, and this analysis in terms of what is involved in deciding whether there's an intention to enter into contractual relations. Again, it's the looking at the picture in the round point rather than narrowly focusing only on the document, and also having regard to the context in which the arrangements are entered into or carried out, because there may be a character such as spiritual, such as the office holder of the judge, which is the explanation for the arrangements and which is not a contract.
Just thinking about the consequences, my instinctive reaction is that if the CRO acted negligently and injured someone else while out on duty, your clients would be vicariously liable. That seems to me to be pretty probable, but that led me to thinking about other areas. You've given us Gillam and Preston. The Diocese of Middlesbrough case is another sort of example where I think, I'll check it over lunch, because it may be a complete red herring, where the Christian brothers were bound to their organisation by hoops of steel, but we're not employed as such.
Quite similar, I mean, because of the wider policy considerations involved in issues of vicarious liability, it's a question of allocating responsibility where it should fall, and so therefore it's a wider exercise in determining whether the relationship is sufficiently close to justify the imposition of liability.
I'm not going to look at that over lunch today, but if we go over, I'll have a look at it and see if I think it's of any relevance.
Very good, well, I'm conscious of the time, but
Well, you were right about timing. Now, what ground you still have to cover, Mr. Tolley? You're going to take us to Grace, and it's not a very long and complex case. What other ground have you still got to cover?
so I was going to cover the cases on, in inverted commas, volunteering. Grayson's the main one to cover. There are two others to deal with a bit more briefly. And then to make my submissions about, in the context of this case, what the relevance or otherwise is of the payment of the amounts described as remuneration. So I believe I could get that done in the half an hour. I haven't dealt with the window point, but I may just have to invite my lords to look at the written submissions on that and deal in reply with my learned friend's procedural objection. But I appreciate I can't, as it were, keep on going and eating into my learned friend's time unfairly.
All right, thank you very much. 2 o'clock.
All rise, if